In today's video, we're answering a very important question. When is it helpful to speak at a criminal sentencing proceeding? So this is an important part of a criminal case. After somebody takes a plea deal, they will then go to sentencing. Sentencing is the moment where the judge actually imposes the sentence. What's going to happen to that individual? What are the penalties? And so sometimes people will call and they'll say, hey, I want to go speak at a sentencing, or our current clients will be going through up into sentencing, and family and friends and everybody will want to come out and speak at that sentencing, which is amazing. At any time that a person who's going through this process has support, that's an amazing thing. We really encourage everybody to be involved. If a loved one or a friend or a family is going through this process, stay involved and be active, be there for moral support. But is it helpful to actually speak at that sentencing? It's going to depend. So in a criminal case, you have a number of different pretrial proceedings. You have a lot of stuff going on as you work your way up until a person takes a plea deal or they decide to go to trial. Not every case gets resolved with a plea. Sometimes they go to a trial. But if you're taking a plea, that plea can be in a number of different versions. And depending on what's in that plea agreement, which is an agreement between the defendant, their lawyer, and the prosecutor's office, depending upon what they put in that plea and what they agree to, that's going to determine whether or not it's going to be helpful to speak at a sentencing, whether it's going to be productive or not. So let's run through a couple different scenarios. Number one, that plea deal that person enters into, that they go into court and they accept, it may include what's called a stipulated sentence. Stipulated sentence means that it's already agreed upon. It's agreed upon between the prosecutor and between the defendant, the person who's been charged. They're agreeing to what exactly the sentence will be, exactly what the penalty is. So let's say, for example, this person is facing a criminal charge that is going to result in some prison time, and the prosecutor and the defendant and everybody agrees it's going to be 1 year, and that's written into the plea. It's a hard 1 year. That means the judge doesn't have any authority to increase that or to decrease it. If the judge doesn't follow the stipulations in the plea, then the parties can pull out of that plea deal. They can actually withdraw from the plea agreement. So if it's stipulated and we know exactly what's going into it, maybe 1 year or 18 months of probation or whatever the actual agreed upon deal is, then speaking at a criminal sentencing is really not going to do much of anything because the judge doesn't have the authority to make any changes. There's no discretion there. The judge can't give more, can't give less. It's all already agreed upon. And so if you're in court and you hear an attorney say, Judge, we just asked that the court follow the stipulations in the plea, that means just follow the plea deal. The judge can refuse to do that. It doesn't happen often, but if a judge thinks it's unreasonable or unfair or unjust, the judge can reject that plea and both parties can withdraw and go back to the drawing board again. Almost never happens, but if it did, that's what would happen. But if it's a stipulated sentence, the judge doesn't have any authority to change or to do anything. There are other situations where there may be what's called an open range, so that the prosecutor and the defendant will agree to a range of potential sentences. So in this example, we're saying, okay, if it's 5 years to 10 years, that's the range based upon the agreement, then it's very important to come to sentencing. The prosecutor, because what happens at sentencing at that point is the prosecutor will then be arguing for what they think is reasonable, and it's usually on the higher end. They're going to be arguing to make it up towards the 10 years. They're going to say, Judge, here are all the factors. Here are the aggravating factors that we believe justify a 10-year sentence. We're asking the judge for a 10-year sentence. The defense, on the other side, can come back in. We can go through a mitigation hearing, a mitigation process. We can submit letters to the court. We can have everybody, friends and family, and everybody come into court and argue closer to the 5 year to argue that that should be the appropriate sentence. Then the judge can pick in the middle. So whoever's more persuasive at that point in time, the judge can find that there are aggravating factors that justify the 10, or there are mitigating factors that justify the 5. There's typically what's called a presumptive term that is kind of right in the middle. And so the judge can then weigh the sentencing on both sides of the arguments and then actually impose the sentence at that point in time. There also could be what's called a no agreements plea. So this means that the prosecutor and the defendant aren't coming to any agreements regarding the sentencing. In other words, they're going into court, they're saying, Judge, we're pleading guilty to this offense, but we're giving the court basically an open range of anything that's available legally under the law. Anywhere in there, the judge can sentence that person to that. So we see this a lot when somebody's charged with a felony, but there's a ton of mitigation, there's bad evidence, it predominantly results in us asking for probation in lieu of prison. So if there's an offense where prison is technically something that can be allowed, but under the facts, under the allegations, under what's being alleged, what's not being alleged, under everything that's in front of the court, it's a possibility that a person can get parole, or I'm sorry, probation, not parole, probation in lieu of going to prison. Or we can structure a settlement where we can say, we're going to ask that the court give this person probation with deferred jail. So if the person screws up on probation, they can go to jail or they can go to prison. Or we can do some jail at front with probation and defer a prison sentence if possible. There's a lot of different options. This is where it's absolutely critical that people come to court and testify at a sentencing. Now, it's up to your attorney to decide who should speak, when they should speak, whether you should speak. Sometimes an attorney will say, I like what you have to say, we're really glad you're here for support, but we just don't want you to speak. You're either too emotional or your testimony at the sentencing is just not going to be helpful. You don't want to be too duplicative. You don't want to waste the court's time. You don't want to have the same types of arguments being made over and over again. In other words, you don't want half the high school class to come there and say, hey, I know Robert's a great guy. And the next person, I know he's a great guy and he's a great guy. Now, all those people can be there in court. They can be there to show support, but it may not be helpful to actually have them come up and testify, to speak at the sentencing. There are other ways they can show their support. They can write a letter. That entire letter can be handed over to the court prior to the sentencing in a sentencing memorandum from your attorney. There's a lot of different ways this can be handled. The point that I'm trying to get across here, it's not always helpful to speak at a sentencing. There are certain scenarios where your support is very much appreciated and we love that you're there, but we don't want you to speak at a sentencing. Either it's a stipulated sentence or what you're going to add at the sentencing itself is just not going to be helpful. It's not going to be productive. Typically, you want the most kind of important people, the people with the closest relationship to the defendant to talk, mothers, spouses, children, people who are going to be the most impacted, people with other experience in the legal system, people maybe like other attorneys or counselors or people who've seen this person actually become very rehabilitated. So this is a question that you're going to need to discuss with your attorney ultimately, but these are kind of the different tiers. You have stipulated sentences, you have open ranges, and then you have no agreement pleas. So if you're in these latter two tiers, you should definitely be preparing to support that person if you know them and love them and you care for them and you want them to get a good deal. If it's a stipulated sentence, they're already agreeing to what they're going to get, and there's not much you can do to change that unless you can get them to make that decision prior to them entering the plea agreement. So keep that in mind. If you're preparing for sentencing, great. If you want our help, if you have some questions about this process, give our office a call. We offer free case evaluations. We're happy to speak with you, happy to give you some thoughts on how you can make this the best sentencing to get the best deal, because we all, of course, want our loved ones to get through this process with the minimal amount of damage as possible. It's a free case evaluation, literally nothing to lose. So give us a call. We look forward to speaking with you soon. Thanks for watching.